A bombing rocks the home of a man with a dangerous past, but the real story begins blocks away with a woman who refused to open the door. This is the Dollree Mapp story. Hi, Amy.
Hi, Meghan. I don't quite understand what's happening in that intro.
Do you mean like you don't understand, like you don't get it, or it's
no,
just
I mean like
wow.
there's a lot happening. It sounds like there's like two stories running parallel. I also, what is the woman's name?
Dollree Mapp.
Dollree is her first name?
Yeah.
Oh,
Yeah.
Very pretty. I like that name.
Isn't that an interesting name?
Yeah.
It's maybe the only time I've ever heard that name, just so you know. So have I intrigued you, though? Have I kind of pulled you in?
You have. And also when I think about like what you said reminds me a little bit of a story that we've covered. Do you know which one I'm thinking of?
No.
What is her name? The pizza bomb guy.
Marjorie Deal.
Right? Just because there's so few cases that
involve a bombing.
Bombs. Yeah.
And a female at the center of it.
Yeah.
Yeah, no, okay. Well, I think you're going to see that this one's different, but this is a case that I know. I don't want to give it away. I love to cover it. It's going to be interesting. It's one that I'm going to geek out on. I just want to let you know.
We say that, but we always do, right?
I'm going to geek out a little extra harder on this one.
And you look a little extra well-rested today.
Thank you so much for noticing. James let me sleep in today, and I feel fabulous, and I'm excited. I'm going out for dinner tonight to one of my favorite spots, Houston's, fantasizing about spinach dip, coming to visit you this weekend. It's a great week.
All good stuff. Excellent.
All good stuff. Okay.
Yes.
All right. So this case is definitely one that I like to cover because it has a lot of legal issues and case law. Again, stuff that I like to geek out about. But as I've said in these cases before, there are real people at the center of these legal decisions whose lives have been drastically impacted. And I think sometimes their stories get lost in the precedent. So today, I'll tell you the story of Dollree Mapp, the woman whose story I hope we can all remember. Dollree Mapp was born in either 1923 or 1924 in either Forest, Mississippi or Austin, Texas, depending on which written source you consult. So there is some variation here. But that being said, one interviewer who spoke with Dollree reports the later date in Austin is correct. So I've seen it as both, but we'll go with 24 in Austin. According to records, Dollree was one of 7 children born to interracial couple Samuel and Mary Mapp. Dollree said that her parents kept a close eye on her. They were strict, but she was always an assertive child who kind of knew she wanted to do things her own way, live by her own rules. And so when she was just 10, she went to live with her aunt in Cleveland, Ohio, with the blessing of her parents.
If you notice, I'm smirking a little because I just realized what case this is and I started writing this case.
No, you didn't.
I did. This is based on a Supreme Court landmark case. Once you said the name, I realized.
It sure is.
But I obviously didn't dive deep enough to even get into the name of the person involved. I was just researching the actual case itself. Excellent. Now I know why you chose this too. Very cool. Okay, I'm sorry. Continue.
And look at your smile too. Now you want to, because you're excited also. Okay. Though she attended school at first in Cleveland, Dollree met an upcoming boxer named Jimmy Bivens, with whom she began a romance. Now, she became pregnant at the early age of 15 and gave birth to a child, her only daughter. And while she and Jimmy married, the marriage did not last long, with Dollree claiming that he was abusive and that she had to leave before Jimmy killed her, or the other way around. But she did seem to like hanging out with the boxing crowd. And she also had some acquaintances in what I would describe as like the lower level of the criminal underworld. So they had a big gambling racket going on at the time. And so she kind of hung out with some of the guys involved in that trade. After Jimmy, Dollree went on to date and become engaged to Archie Moore, a lightweight boxing champion. But the engagement was brief, and she later sued him for breach of promise when it ended. Which is really interesting. I know you can, but I haven't heard of anyone actually doing it before. I don't know what the outcome was, if they settled. I didn't see that part, but I thought it was interesting. In 1957, Dollree and her daughter were renting half of a boarding house in Cleveland, Ohio, when a bombing of another local resident occurred. And the person's house who was bombed, I'm pretty sure you'll know the name. On May 23rd, 1957, the home of later famed boxing promoter Don King was bombed.
Interesting.
Yeah, you know the name, right?
Yes. Did you ever know that when you knew this case? Did you ever know this had anything to do with it?
I did, but
Really?
not much.
Okay.
So I kind of went down a rabbit hole a little bit on this. Luckily, only the porch was destroyed in the explosion, while King and his girlfriend, who were home at the time, were unharmed. But the police received a tip that a suspect named Virgil Ogletree had carried out the crime, and that he was staying at the home of a woman named Dollree Mapp. But before I get to that part, I want to give you a little background on Don King.
Yes. A lot of our listeners are very young. They probably don't even know who that is.
I mean, his hair is probably more famous than him, the tall hair that used to stand up. And he is very famously known as one of the most controversial boxing promoters to enter the sport, having represented many well-known fighters such as Muhammad Ali, Joe Frazier, George Foreman, and Mike Tyson, Tyson later claimed that King's corruption ruined the sport of boxing. You know, Tyson was also vocal in saying that Don King, who is also a black male, did more to ruin the sport than any white man could have done.
Oh. What does he say? Like, I know that's not what the focus is of today, but very briefly, what does he allege that Don King did?
He took a lot of the money. He
Got
just
it.
basically took a lot of money.
Okay.
I mean, there's other things. They allege there were all sorts of allegations of fraud that King stole from these boxers, basically. But before he became a boxing promoter, he also had a very sordid criminal history. Born in 1931 in Cleveland, Ohio, King's father died in a steel explosion when he was a child. So Don King's mother moved him and his siblings to a middle-class neighborhood. But, well, let's just say it this way. King opted out of college and into gambling. So he was one of the people involved in this gambling racket, running gambling houses essentially in Cleveland. And then in 1954, he shot a man who attempted to rob one of these places. And the man died.
Oh.
The killing was ruled justifiable, though 13 years later, King was indicted on murder charges again. In this incident, Don King beat a man to death on the street who owed him $600, literally stomping the man to death while the man said, I'll pay you, and died from traumatic head injury.
Wow. So I'm assuming he went to prison.
Listen to this. He was convicted of second-degree murder, but his lawyer, crafty lawyer, was able to get the conviction reduced to manslaughter, and Don King was out of prison in less than 4 years for beating a man to death.
Sometimes money can buy you a good attorney.
That's true. And then Don King would later go on to become a boxing promoter, and a record one at that, but again, mired in allegations of fraud and corruption of the sport. He's been involved in many lawsuits with boxers with mixed outcomes, and while he's also been indicted multiple times on tax evasion and fraud, he's never been convicted again.
Oh.
Yeah, he's clever. I forget who it was, but someone once called him the smartest man he's ever known in terms of working the system.
He's not still alive, is he?
Don King is still alive. I think he is. He was born in 31, so my math is terrible, but he's whatever
that's
that
old.
makes.
He's like, what, 94?
In his 90s, yeah.
Yeah. Okay.
Now that you have some extra context, I just thought that was interesting. Let's rewind to the night of 1957 when King's home was the target of a bombing. At the time, Don King refused to pay local gangster Shonda Burns, who demanded money in exchange for protection from locals running betting operations. Now, I'm sure you've heard of this racket before, like the mafia demanding protection money from businesses. You pay us and we'll protect you. Really, they're just protecting them from themselves. But okay, King apparently paid for a while, but then refused, defying Shonda. And according to King and others, it was Burns who bombed his home, or at least the muscle that worked for him. And this is what led police to Virgil Ogletree. Now, where to find Virgil? Apparently, he was known to hang out at Dollree Mapp's home. So that's where the police were headed, but things would not go as planned. The police knocked, and Dollree Mapp opened the door to her home. Though Dollree didn't have a record, she was known to the police for her affiliations. This was a different time, Amy. Police knew people in their communities. This is also the time of foot patrol. So you might even say real community policing then, prior to the age of, redeclaring community policing. So 3 officers arrived and asked for permission to search her home. But Dollree Mapp called her attorney, who advised her not to let the police in without a warrant. And if they can get a warrant, make sure to read it, he said. A few hours later, the police returned in force, this time with about 3 to 4 times as many officers. And they entered her home by forcing a door open before she could get to it.
Without a warrant.
Well, once they entered the home, an officer waved a piece of paper in front of Dollree saying he had a search warrant. She demanded to see it, and when the officer refused, Dollree grabbed the paper and shoved it down her blouse. What did this officer do? He reached right down her shirt and grabbed the paper back. The officers then handcuffed Dollree, who was described as belligerent. They proceeded to search the house, and they found the man they were looking for, though he was later cleared of the charges. And his story becomes less of the focal point of this case. After finding him, they continued to search Dollree's home, and they found books and drawings that belonged to a previous boarder, according to Dollree, that they deemed sexually explicit. There were some nude drawings and erotic comic books. Ironically, if you see the comic books, you just think they were probably funny, not anything terrible. But at the time, Ohio law prohibited possession of obscene materials. So these were considered lewd and lascivious photos, books, and drawings. And as this was a felony charge, Dollree was arrested for having obscene materials in her possession. And even though some of those comic books might have been funny, nobody was laughing because Dollree was facing between 1 and 7 years in prison. But she wasn't about to go down without a fight. Dollree Mapp took her case to trial, securing bond so she was not incarcerated at the time. At her trial, Dollree's attorney motioned to have the evidence excluded as it was found without a warrant. Now, the exclusionary rule prohibits evidence found in violation of our constitutional rights from being presented in court. It's not admissible, meaning it can't be used. Which case actually established this rule? Well, that was Weeks versus United States, 1914. In this case, Weeks, I think it was Fremont Weeks, was transporting lottery tickets through the mail. Now, gambling is largely regulated at the state level, so when lottery tickets cross state lines, it is considered, I think, violation of interstate commerce. It undermines state control, and it allows participation in lotteries that are illegal in the recipient state. So law enforcement got wind of this, and they entered his home without a search warrant, seizing papers relevant to the scheme, which they used to convict him of illegal gambling across state lines. But Weeks appealed all the way to the U.S. Supreme Court, who said that the evidence was obtained in violation of the Fourth Amendment. So great, the exclusionary rule existed at the federal level. But what's the problem, Amy?
States are free to decide how they want to how they actually want to do this in practice. Obviously, the death penalty moratorium in the 70s is a perfect example of this.
Yeah. So the rule didn't apply to states at the time, just the federal courts, because of the separation and the dual system we have. The Supreme Court also handed down another decision that I think is important to this case in Wolf v. Colorado in 1949, saying that states have the protection of the Fourth Amendment. So we have the protection, let's say, to the right against unreasonable search and seizure. But they didn't have to extend the exclusionary rule to the states because the exclusionary rule, it's not a constitutional right. It's considered a remedy. So the states don't have to use this remedy. They're free to choose to have a remedy or not to. And at the time, Ohio did not have this protection for the Fourth Amendment when the officers searched Dollree's home.
I'm assuming, you didn't say, but I think it's assumed that the paper he waved was not, in fact, a search warrant.
There was no search warrant.
But even if it were, she should be allowed to look at it. So we'd be talking about this case probably in a different way. We
would definitely be talking about it. And Dollree was a fighter. So even, she definitely would not have, and I don't mean a physical fighter. I mean, like, she wasn't about to take that. So you do have a right to view your warrant. You have to look at it, though. You have the right to see what officers are doing, that they abide by it. So a warrant can't be hidden from you.
Yeah.
But at the time, also the way that the police searched her home wasn't uncommon. In fact, a law professor, Lewis Katz at Case Western Reserve University in Cleveland, explained, quote, "The illegal entry of Mapp's house by the police was nothing extraordinary. It was an everyday fact of life for Blacks and other racial minorities. Police throughout America were part of the machinery of keeping Blacks in their place, ignoring constitutional guarantees against unreasonable arrests and searches and those that barred use of third-degree tactics when questioning suspects." Thought that summed up the state of things very, very well. So what ultimately happens here is the state of Ohio allows the evidence at her trial, and Dollree is found guilty very quickly and sentenced to the maximum of 7 years in prison. And no doubt here that I would also say the fact that she was a Black female resisting the police played a role in both the way they treated her at the policing level, but also in the courts.
How are they explaining giving her the max? She had no criminal history, right?
No, I'm not sure how they explained giving her the max.
I don't think they have to, actually.
No. They definitely
But
don't.
I'm just curious if there was any commentary.
Not that I saw. I'm sure there
Okay.
was, but not that
Yeah.
I saw. Now, Dollree, who was still out on bond at the time, appealed the decision. But interestingly, she was arguing, and I didn't realize this per se, that the Ohio law of possession of obscene materials violated the First Amendment right to freedom of speech, which was interesting because it was a unique law somewhat to Ohio. Though Dollree lost her arguments in the Ohio Supreme Court, she'd get another shot, and a big one at that. The U.S. Supreme Court agreed to hear Dollree Mapp's case, and at first what appeared to be a First Amendment issue quickly turned into a Fourth Amendment case. So was Dollree's Fourth Amendment right violated? Yes, it was, in fact. But should the remedy apply to her case, and should the evidence have been excluded? The court heard arguments from the state and from Dollree's lawyer, but also the ACLU joined the fight, which is not a surprise here. They provided an amicus brief to the court. We've talked about amicus briefs before, right? It's like a friend of the court brief.
Yeah. It's just to provide information to help the court make an informed decision. Is that correct?
Yes, absolutely. Okay. But the ACLU is very invested in this decision as well. Now, they also focused mostly on the legality of the obscenity law. And then from what I read, something like very briefly at the end of this brief, they mention the Fourth Amendment issue, the unreasonable search and seizure. But the court grabbed onto it. They were way more interested in the Fourth Amendment issue. On March 29th, 1961, oral arguments proceeded. But again, it was a little bit complicated because the justices were asking, is this a First Amendment issue or a Fourth? The ACLU quickly said, we're going to look at this as a Fourth Amendment issue. And they were asking the court to overturn that earlier decision that I mentioned, Wolf v. Colorado, meaning that they were asking to apply the exclusionary rule to the states. That was the issue. So we want the exclusionary rule, even though in Wolf it said like it didn't have to apply, which is kind of a big deal because they're asking the court to overturn its own precedent. So what did the state have to say? Well, this is what they said. No, there wasn't a warrant. It wasn't real. And it was totally made up. But ultimately, it's our right to use the evidence or not, since there's no prohibition of it. And again, it's states' right. We can choose to do whatever we want to do, which is such a icky argument, but it was true legally. So the court has to decide if it's going to overturn a precedent and impose federal law on the states or let the decision stand. What's the term for that? Let the decision stand. Stare decisis.
Oh, yes. I remember that.
See how you just get to geek out on these episodes?
Yeah.
Isn't it fun? No. Sorry. All right. In the end, the court ruled in a 6-3 decision that it would overturn its previous decision in Wolf, and the evidence used against Dollree Mapp would be thrown out because it was obtained illegally, meaning the exclusionary rule would now be extended to the states through the Due Process Clause of the 14th Amendment. The ultimate argument here, and I think the best one, what's the point of the Fourth Amendment if there's no deterrent to abide by it?
Absolutely correct. And we'll probably talk about this at the end, but it's safe to say that this is one of the most foundational Supreme Court decisions in the last century.
Oh, I have a whole section on the due process revolution.
Okay.
Okay. But, Amy, there's more to the story. Let's come back to Dollree. What happened to her after the decision? After she finished her legal battle and her conviction was vacated, she moved to Queens, New York. But that wasn't the end of her dealings with the police. In 1971, the police knocked on Dollree's door again, but this time they had a warrant to search her home. And during the search, they found receipts and other documents that linked Dollree and co-defendant Alan Lyons to an apartment that contained approximately $150,000 worth of heroin and other stolen property. So it was a drug house, essentially, and they're linking her. They're saying she's part of a drug operation. Dollree took her case to trial again, claiming that this was an obvious setup, payback for her win in the Supreme Court and her role in that major decision. But Dollree's arguments did not prevail, and she was found guilty of possession of drugs. And unfortunately for Dollree, she was convicted and sentenced under the newly passed Rockefeller laws of New York.
So she got herself a long sentence.
Oh, yeah. Let me explain this briefly. I mean, had it just happened a couple of years before, she was sentenced in 1973, and that's when the Rockefeller laws passed.
Oh, boy.
So the Rockefeller laws were passed by then Governor Nelson Rockefeller, and they were a harsh form of mandatory minimum sentencing. For people who don't know mandatory sentencing that well, I'll just explain briefly. Mandatory minimums establish a sentence that a judge cannot go beneath. So most sentencing before that has what we call mandatory maximums. So you could be sentenced to no more than 20 years or 30 years for a crime. But now you flip that and it's no less than 20 or 30 years. So basically, it removes all discretion from the judge.
And it shifts it to the prosecutor. Well, the power shifts to the prosecutor because they get to decide what to charge at this point, and they're essentially deciding the punishment.
They are. And I mean,
the minimum.
People are already kind of coerced into plea bargaining, but now if you think about it, a prosecutor can say to you, oh, if you don't plead guilty to this drug charge, I'm going to charge you with a mandatory, and you're screwed. So like it's even more coercive.
Yep.
Yeah. So for Dollree's crime, she was sentenced to a mandatory minimum of 20 years in prison.
20 years.
20 years. And this was a shocker for everyone.
Wow.
Dollree was sent to New York's female prison, Bedford Hills, where many famous convicted females have served their time, some of whom we've covered. You know, Amy Fisher was there. We've covered her. I covered Lacey Spears. I don't know if you remember her.
Wasn't Nikki Adamando there as well? She spent
Nikki Adamando was there. Yes. So Lacey had poisoned her son, Garrett, with salt. There have been others, like Stacey Castor was there. Yeah. Needless to say, Bedford Hills. I mean, it's the only female prison in New York, so it makes sense. I forgot Nikki was there. I always think Nikki is a New Jersey case for some reason. Inside, Dollree lobbied against the mandatory minimum requirements, of course. She worked with other prisoners to obtain more rights for the women inside Bedford's walls. She was very active inside prison as well. In 1980, though, her sentence was commuted by the governor at the time, and she was paroled early, serving just 8 years of her mandatory 20-year sentence.
Now, does that have to do with her behavior in prison? Does that have to do with them dialing back on mandatories, or maybe the fact that she was involved in the Supreme Court case? Like, what do we think?
I think the governor after, I forget which governor it was it Governor Perry? I think he wasn't such a fan of the Rockefeller laws, and she was, quite a famous prisoner. Who knows also? Maybe she was making trouble on the inside. Maybe it was just, and I mean making trouble for authorities. You know, maybe it was just easier and quieter to release her. And whatever the reason was, she was released after 8 years. Following her release from prison, she worked at an organization that helped provide free legal advice to incarcerated people.
That's cool.
Dollree, what's that?
That's great that she went on to do that kind of work.
I mean, it sounds like she was doing it from inside prison. I think she always considered herself maybe an advocate after the Mapp decision. But Dollree was also a very talented seamstress and dressmaker. So she had her hand in a number of also businesses. So I understand that she was pretty successful that way. And she went on to speak at many different colleges and law schools about her involvement in the system. Referred to as the Rosa Parks of the Fourth Amendment, Dollree Mapp remained unapologetic for standing up for what was right until she died in 2014 at age 90 or 91, depending on which is her birth year.
Huh. Wow, so that's so interesting.
Right? And I never would have looked into her after story, what happened to her afterwards. So
yes. And to tell you the truth, I teach that class. Obviously, you can't teach criminal justice without teaching that Supreme Court case, Mapp versus Ohio. Yeah. But I never really knew the details of it.
That's one of my favorite one of my favorite parts of teaching. So I teach policy analysis, and we do a lot of case law, a lot of cases in that class, but I love telling the stories behind them because obviously our students get so much more engaged when they know the stories and when I'm not just going through the exclusionary rule, this rule, that rule. So I thought it was really interesting. Okay, now that we know Dollree's story, and of course it's not the full story, but it's as much as I could find, I want to talk about the significance of Mapp versus Ohio. Mapp marked the beginning of the due process revolution in the courts, and this was under Chief Justice Earl Warren, the most significant decisions, and there were several landmark decisions to follow. So what happened during this time is a lot of criminal procedure protections were extended to the states. We'll start with one of the most significant decisions. So not everyone was guaranteed a right to an attorney at the time until 1963. Amy, what case?
Gideon versus Wainwright.
Gideon versus Wainwright, yes. So significantly, at this point, attorneys would be provided. Before then, attorneys were provided to people in capital cases. Now, anyone who cannot afford an attorney. And as we know in the system, most people cannot afford an attorney. I think in the state courts, 80 to 85% of defendants are indigent and can't afford an attorney. Everyone would also be read their Miranda rights in an effort to protect our Fifth Amendment right to remain silent.
You just covered that case, right?
So here's what I forgot to say this in the beginning, but I did just cover Miranda. I covered Miranda. I also covered, if you remember, Roper v. Simmons, which is the case that prohibited executions for juveniles.
Yes. You've been doing a lot of these.
I covered both of those for our supporter-only episodes.
Oh, okay.
And I realized that. I was like, I've been covering them. And I love doing that because obviously we love to geek out with our supporters and we have so much great conversation. But I wanted to make this one available to everyone just because I thought it's time to start talking case law with everyone. Okay. Now, there were many other decisions that followed and several that people are not aware of in the juvenile system. So I just want to briefly say about the juvenile system. Until the 1960s, juveniles could be tried for crimes, adjudicated delinquent, which meant detention in a juvenile facility. And all these words are like the language of the juvenile courts, but it essentially means you're being found guilty and placed in juvenile detention, which is the same thing as prison, only at the juvenile level. So loss of liberty, right? But they had no rights. And there were a lot of different cases that actually changed this, but the most significant, by most accounts of legal scholars, was In re Galt in 1967. And this was the case that granted juveniles due process rights to receive, to have an attorney, to confront witnesses, to be read charges against them, and the right not to self-incriminate. Do you remember the case of Galt, what the issue was?
I don't. I teach it though, but I can't think of it right now.
So he was a kid who was making prank calls, lewd prank calls to his neighbor. And they arrested him, took him basically to courts, never told his parents, forced him to basically confess with no attorney. And within something like a day or two or a couple of days, he was adjudicated delinquent. But get this. So lewd calls, nobody would even get a jail sentence. And if you did, I think the maximum allowed by law as an adult would be 30 or 60 days. Galt was sentenced to 7 years in a juvenile detention facility.
How old was he?
15.
Wow.
And the judge at the time wouldn't even let him hug his parents goodbye. It was the craziest thing. So anyway, he appealed his decision. I've read testimony by him. He gave interviews, and it was just almost heartbreaking. Who hasn't made prank calls as a kid, by the way? I was thinking that.
Yeah.
Okay, so Galt gives juveniles due process rights, and there were a number of other cases that did. So that's part of the due process revolution. The case of Mapp obviously also changed the way police did their jobs. For one, now they had to secure warrants for searches unless they had exigent circumstances. which, do you teach exigent circumstances?
Well, not only that, besides exigent circumstances, there's also all those other ones like second party consent, plain view, right? There's some other exclusions as well.
I'm going to actually get to that.
You are? Okay.
Yeah, I'm going to get to that in 1 second because at the time that Mapp was passed, it was really just exigent circumstances, I think.
Oh, interesting. Okay,
Because
so that's
those
pretty much
other-
emergency circumstances. Like if they're looking
Yeah.
for an active gunman and they have reason to believe that that person ran into your house, for the safety of the community, they can enter your home without a warrant.
Yeah. So the police had to be they had to learn what's exigent. They had to be able to articulate that. In obtaining warrants, they had to be very careful about respecting boundaries of warrants and evidence collection procedures in accordance with what was legal to search and to process. So it's kind of learning evidence now again. They became more professionalized from Mapp, I would say, and Miranda and other decisions in terms of also receiving much more training in constitutional law and criminal procedure.
And the critique would be, though, that it hindered their police work, right?
You know what? My next line, of course, there was a huge backlash with fears of law enforcement that they would be losing valuable evidence and investigative tool.
Yes.
That is true. But as you just pointed out, and just like Miranda, there are many exceptions to the rule. So I'm just going to cover a couple of exceptions. At the time of Mapp, so the exclusionary rule pretty much held in exigent circumstances was kind of the only exception. Now, other exceptions have been carved out over the years. I think the most, you teach some of them. For me, the most well-known one is the good faith exception.
Oh, really? I would think plain view is... But good faith is interesting.
Okay.
I didn't know that good faith was used that often, but I'd love to hear about it. Maybe I don't fully understand it.
You know what? It might just be the one that sticks with me, too.
It's an interesting one.
There's so many exceptions to the rule, though, that I could not cover that in this case because we are running out of time. But good faith was established in United States v. Leon in 1984. And in this case, Leon was the focus of police surveillance based on a tip from an informant. So they got a search warrant for his home based on their surveillance. During this search, they recovered drugs, but at the trial, the judge found that the search warrant didn't contain enough probable cause to search the house. So the evidence was excluded, but the case went up to the Supreme Court, and that's where they created the good faith exception, which is basically that the police, it was a mistake. So they executed the search warrant in good faith just because the warrant didn't establish probable cause. It wasn't their fault.
I've also heard if it's like a clerical error and they put the wrong address on a warrant. I actually heard of a case where they went to like 132 instead of 123.
Yes.
It was a clerical error, but it's fair game. If they find something in good faith, they can use it against you.
So that's another one. In Herring v. United States, 2008, the Supreme Court also carved out an exception, holding that the exclusionary rule doesn't apply when the police mistakenly execute a warrant on, in this case, it was a recalled warrant. So like the warrant was issued, it was recalled. The police didn't even realize it was recalled. So they executed the search. And the court said this wasn't like systemic negligence. This was a one-time error. So that error also is an exception.
Yeah.
You talked about plain view doctrine. Can you explain that?
Yeah, I love plain view. It's one of my favorite ones to teach because it's so circumstantial. And this could be with not only visual, but also auditory. So, for example, if you're, say, in a Starbucks, and let's say you and I are in Starbucks and I'm telling you about the body I have buried in my backyard, and there's a police officer and they're not doing anything outside the scope of their duties to listen into our conversation, they can seize that information and use it against me. Plain view, if the police come to your home, say there's a missing puppy in the neighborhood, they knock on your door, you willingly open the door. Yeah. You even invite them in or don't invite them in. But if they're talking to you about this puppy and they see your meth lab in the background, they can use that against you. Yeah. So as long as they're not doing anything outside the scope of their duties. For example, they can't have binoculars. They can't stand on their tippy toes to look over a fence. One of the most interesting examples, or the one that I like to use with my class, would be if you have a police officer walking down the street and, they smell marijuana. And then they look and they see that you have marijuana plants in your backyard, right? Now, it could go either way. The smelling could be the probable cause to then look over the fence. But let's say that they just see it without even the smell. That's fine. But if they had to go on their tippy toes to look over the fence, that's not plain view. Now, if a car came by and knocked the fence down, and it's just like dumb luck for the officer, and knocking down of the fence reveals the marijuana plants, fair game, plain view. I love plain view. So
plain view is so interesting because of
is.
those small little details. Like, was an officer standing flat foot or standing on the tippy toes? I love that kind of.
Another, may I go on one more?
Yeah, this
tangent?
is a geek out.
So if the search warrant says that you're looking for a firearm, you're only allowed to look in places that could reasonably hold a firearm. So in other words, you couldn't look in a jewelry box that's tiny because there's no like mini gun, right?
Right.
So that wouldn't be admissible. However, if you look in a shoebox where a gun could be and you find someone's cocaine, you can use that against them because they were allowed to be looking there. So it falls under plain view.
Yeah. Wow.
So there's so many more examples. I love plain view.
Yeah. Are you teaching that in criminology? Like, what do you teach that in?
And when I teach intro and we do criminal procedure. So you should teach that when you teach criminal procedure this fall.
Well, what's great about this fall is that for the first time in since John Jay, so maybe 16 years, I get to teach just intro to criminal justice again, not criminology.
And you will be using
our textbook, probably. Yes.
Yes.
Oh, yeah. I am probably going to use our textbook, even though sometimes I don't like when professors do that. Our textbook is smaller. It has personal stories, and it's so much more affordable.
And the professor who taught the class before you used it. So it's not like you're choosing to use it. You're just following suit. So
at the other campus. But yes, that is
and
very
yes, we
true.
might make 75 cents on it, but we'll donate it. We'll donate it back.
I am really excited about it. I think you carved out, I probably have other exceptions to the rule, the inevitable discovery. Let me just cover that one more and then I'm going to move on.
Okay,
We're almost there. But there was another one, Nix v. Williams. I always found this interesting because it also happened in 1984 when Leon happened, which so the Supreme Court taking this issue in the same year is kind of interesting. And they announced the inevitable discovery exception. And that was, in this case, Williams had abducted and murdered a young girl, and the police officers convinced him to reveal the location of her body. So the court decided that the exclusionary rule would not apply in this case because her body would have been found without the admission.
Oh, interesting.
So it's an inevitable if the evidence is going to be discovered. So like when we talk about the constitutional right or the remedy of the exclusionary rule and the concern that police will lose all this evidence, look at all the exceptions.
Can I say one more? I'm sorry.
Sure,
Talk about geeking out. Fruit of the poisonous tree doctrine.
Yep.
So interesting. I won't get into the case itself, but essentially it says if evidence is seized illegally, anything it leads to is non-admissible.
Yes.
So if they don't have a search warrant and they find a map in your house that leads them to a dead body, they can't use that body against you if the map was not seized legally.
Yep.
So I find that interesting. And I think it makes sense. Hence the name, Fruit of the Poisonous Tree. Yeah.
So with every constitutional right and remedy, there are many, many exceptions. I think we've made that clear. And I'm sure we're going to get someone who's going to write, you forgot this one. I'm
there's
sorry.
so many.
Yeah, we don't have time for all of them. But
automobile search, there's so many. You could go on and on.
That's one students always ask me in class. I got pulled over and they wanted to search my car, and I'm like, oh, here we go.
Search incident to arrest. I mean, the list goes on.
Okay.
Sorry, I'll stop.
No, it's okay. We could probably do a whole podcast just on that or teach a whole course as we will or as I will. Yay.
Yeah.
All right. So did the system get it right? I like this question for this case because that depends on who you ask. Many applaud the application of due process rights being extended to the states, while others argue this was not the original intention constitutionally. And they also argue, or others will say, these protections hamper criminal investigations. The states should have had the right to decide. As the Supreme Court, I think, pointed out, though, one of the main problems here is what's the point of a right without a remedy? The states having the right to decide and not being bound by federal doctrine applies. So this is very complicated. For me, this is a complicated issue. There's arguments on both sides legally and practically that apply. Ultimately, I think the exclusionary rule was created in the federal courts and extended to the states to protect our Fourth Amendment rights because many states didn't allow people like Dollree Mapp protections. So if you weigh the pros and cons, I'll tell you, I can see both sides, but in the end, I'll take it. That's just the truth.
I would agree.
Okay. And in the end, it was one woman's demand that her constitutional rights be respected that got us here. So thank you to Dollree Mapp, a woman whose story we won't forget.
Yes.
So fun. Now you want to do cases, right?
I know. I might have to do a case for my next one.
You might have to soon. All right. But before we go today, Amy, we have a question from someone who emailed us.
Great.
When you discuss bail reform, what would that look like for individuals accused of targeted crimes such as stalking and domestic violence? Are there stats that they're unlikely to reoffend while awaiting trial? Because it seems in these stories, in most of them, their behavior continues after arrest or can even escalate. So this person appreciates bail reform, but is really just concerned, I think, about these certain crimes and protection of the community. I think this is a great question. I love this question. Do you mind if I kind of take it?
Well, no, this is one of your areas, so I think it makes sense that you go.
So while I support bail reform, this person, and I don't know the exact stats, I will tell you, of the reoffenses during the bail period in particular, I can tell you absolutely people who are committing crimes of stalking and domestic violence are usually more likely to recidivate. So they're less deterrable. However, it's complicated because not all stalking is the same. So it is definitely possible the person who gets caught and processed in the system is going to stop. And it's possible that they're not going to. So what happens in these cases is it's a consideration. There's a risk prediction that actually is compiled. So do they possess the factors? Can we predict that they might be a higher risk? If so, bail might not be appropriate at all. So it's not that financial bail should be higher. It's that maybe they're too dangerous. Or if it doesn't seem like they pose such a danger, you can just place a number of pretrial restrictions on them. So they get close monitoring. They could even get electronic monitoring, which I think is a very good way to prevent or to protect someone else. There's also a restraining order that would probably be placed to protect the victim. So in short here, I think the answer is yes, they are. I would say it's a higher risk of recidivism with those crimes, but I think there are many ways to ensure that that does not happen. And if that's not possible, then I would support remanding them if it's going to serve protection of the community.
Well said. I don't think I have anything to add there. So thank you.
All
And
right.
thanks for that question. It's a great question.
Yeah, it was a great question, I thought. All right. Well, listen, thank you everyone for listening today. I also want to point out that if you are interested in, joining us for some more cases that involve precedents, but learning the stories of the women behind these massive legal landmark decisions, then think about joining us on Patreon because we are sure to keep geeking out over there.
Mm-hmm.
All right. Thanks everyone for listening, and we'll catch you next time on Women in Crime. Women in Crime is written and hosted by Meghan Sachs and Amy Shlosberg. Our producer is James Varga. Script editing is by Abagail Belcastro. Audio editing is by Siler Burr and Jose Alfonso. And music is by Desert Media. If you enjoy the show, please remember to follow and leave a review. You can also support the show through Patreon, where you can get access to additional ad-free content such as exclusive full-length episodes, lectures, a book club, and virtual happy hours with Meghan and Amy. For more information, visit patreon.com/womenandcrime. Sources for today's episode include The Marshall Project, Mapp v. Ohio, 1961, The Patriot Ledger, The New York Times, The LA Times, Justia.com, and the League of Women Voters of Muncie-Delaware County.